main objectives are to assess India's regulation of CSR and also look at the role of institutional shareholders in trying to actually regulate or govern corporations. Shall I press that or not? Okay. Oh yes, I should turn this on. All right. Thank you. So quite briefly, the morality of the company is where we start off. We explore the fact that the company doesn't really seem to feel a moral duty to try to take care of any harm that might be caused to the community or to the environment. And if it's only responding to share price, the way it reacts is limited. So what we're recognizing is that share price and the actors who care about share price is, as we know, shareholders. But going back again to the old thing of Berlin means, we know that majority shareholders don't care and they don't act. So the whole notion of shareholders being able to regulate a company is a flawed concept. So the idea of morality of a company comes back into question. How does a company also satisfy some other responsibilities that it has? It's making a lot of money, it's making a lot of profits, and it's making it globally now. So what's happening is no longer is the actual loss being caused within the country in which the profits are made. This also is divided. So the idea of trying to make the company responsible for the actions has come up much more in the last 10 years. And the question really is, why should the total loss not be taken into account? The loss that the company actually is contributing to making, environmental loss, employment loss, actually cancelling contracts with suppliers who have entered into contracts with it because it goes into financial difficulties. Why should the profits only lie with the company and not the losses is a question anyone can ask. And I think those issues like the Satyam case brought this to the fore. And of course, how can the stakeholder police the corporation's morality? And we know, therefore, that that isn't really happening effectively by shareholders. So the object of this class is to look at two things. Firstly, CSR, which is been stuck into the Companies Act of 2013. It's a first of a kind to actually have a provision that prescribes how much should be spent on CSR. It's a world first. And secondly, to look at how you can direct other people to police companies as well. So the CSR framework is pretty straightforward. It's in section 135. And it basically says that if you have a turnover, a net profit or a net worth of the amounts listed on this slide, namely 1,000 crore, net profit of 5 crore or a net worth of 500 crore, then the CSR provision automatically applies to the corporation. It asks that all companies, whether it's private, listed, public, every company is obliged to follow the CSR requirement. Note, of course, that listed companies have much more. They have got to also follow environmental disclosure provisions. But this applies across the board. And how is this actually implemented? Well, it's implemented by asking the company to set up a committee, a CSR committee, that will then decide the spending that has to be done on CSR and what activities will be funded. As it says, the CSR committee is supposed to have 3 directors, at least one of whom should be independent. Now, the important thing about any provision is to figure out if it's going to be effective, is to have a look at the penalties or the results that will ensue if there is a breach. And it appears that although there are 8,000 companies that are definitely going to come within this provision, it's very clear, the provision section 134 when you look, sorry, 135 when you look at it, looks like you must. It looks like a mandate. It looks like a hard law. But what it comes out with is it basically says if you don't follow it, the directors have to explain why they haven't. So all that happens is the directors, in their director's statement, have to give reasons why the 2% of money has not been spent. So it is what is called a comply or explain model. So you either comply with the law or you explain why you haven't. This is the common model that's followed in other countries for things like gender parity, or even for, I suppose you could say it's even for ESG, or environmental, social, and environmental social governance. So not just profit, but when they're looking at environmental impact and social impact, they have to explain how much they've spent. And if they haven't spent much, they have to explain why. So that is the model that's been followed. So according to 134, there has got to be a disclosure. If you've spent it, cool, you state how you've spent it. If you haven't spent it, you give an explanation. And if you're not able to do that, then there is a fine that can be applied. But as you can see, the range of the penalty, it should be 5 to 25 lakhs. 5 to 25 lakhs if the company fails to specify the reason why it hasn't spent the set amount of 2%. So any provision you've got to look at, it might look like a hard law, but then you've got to ask the question, is it really a hard law? And it looks like this is a voluntary guideline, and if you don't spend it, you might get this fine. So it's up to you to decide whether the fine is big enough to force compliance or not. So that is the CSR framework. The committee has to be established, and the committee is supposed to be a minimum of 3 directors. 1 out of the 3 is an independent director. And there is an exemption for unlisted public companies and private companies. They don't have to appoint an independent director. Private companies and a foreign company only have to have 2 members in their CSR committee. And board report is to disclose the composition of the CSR committee. So although you've got this idea, it's 3, note that if you're an unlisted company or a private company, clearly that is diluted and slightly different requirements apply. But as I said, it's a first. So what does the committee do, this CSR committee? Well, it's supposed to formulate the CSR policy for the company, and it's supposed to look at Schedule 7 of the Act. And Schedule 7 prescribes what can be taken into account, what is considered CSR activities. It decides how much is 2%, firstly, and it recommends the amount that should be incurred, whether it should be 2%, whether it should be less or more. It monitors the policy from time to time, and it provides a monitoring mechanism to keep an eye on whether this expenditure is actually taking place. So what is happening here really is the government is asking the company to set up an internal mechanism for monitoring CSR. The government, through the law, isn't asking or imposing an oversight. It's asking the company itself to build a mechanism of oversight. Very much a soft approach. Comply, explain, develop mechanisms, do it. If you don't, say why and tell us when you're going to do it. in an effort to try to understand this further and to get your input, I just thought I would give you two separate problems that you could consider. And I thought I could split the class in half, so this group can be one and that group another. The first problem, perhaps you guys could look at problem number 1, and this group can look at problem number 2. The first is the CSR committee is making pesticides. Think UCC. And are aware that there is a good deal of backlash against the company by the local NGO on environmental grounds because it's going to be a leakage of noxious chemicals. There has been, and the community is being affected, and the NGO is raising concerns, raising alarms. So it's to advise the company on what kinds of CSR activities it should engage in. So that's the first question. So I suppose in looking at that, I'm asking you to look at the schedule, to look at what kinds of activities can actually be used as CSR, and also to develop a policy which can do that, as well as that perhaps still retain the interests of the shareholders in mind and not completely lose their attention. So how do you minimize this damage? But how do you also develop a policy that meets these requirements plus profit? The second question is on a company selling baby formula to rural areas. The business is going well. However, there has been a good deal of notoriety in Pakistan that baby formula is being sold to rural areas, but the people are mixing baby formula with impure water, and it's causing significant diseases of malnourishment and diarrhea among children. So that company also has to use the 2%, so advise it on what kinds of activities it can engage in. What I'd like you to think about is I'd like you to develop the minimum. What is the minimum that can be done that maximizes profit, and what is the sort of good citizen option that can be done? And I'd like you to give that back to us. So when you develop that, you can present your case and the other side will ask questions. And when you develop that, you can present your case and the opposite side will ask questions. So that is a policy. Can I give you perhaps 10 minutes? Oh no, do you think you need 10? Yes. 10 minutes to think about it, look at Schedule 7 and come back with your recommendations. Thank you. Okay, thank you. Maybe we should get back to it now. All right. Now, shall we start with question 1? Well, they don't seem to want to start. They want you to start. So maybe we should start with question 2. Is that all right? Lovely. But you have to pay attention to their presentation. So you're actually like a combination of stakeholders, NGO plus institutional investors plus shareholders, and they're going to present. So do you want to come up and tell us how you would do it? Yes, you're going to start. There you go.
So we've identified that the problem that might be caused is because of the certain impurities in water that can be mixed with the product that we are selling. So we've identified that there are certain ways in which this problem can be avoided. Now we've referred to entry number 1 in schedule number 7, which is pretty broad, and under that we're proposing that we can. All right, so we plan to have grassroots level campaigns encouraging the use, encouraging clean drinking water. We're basically proposing that we could raise the awareness among households in the rural areas of how to purify water in their own homes, and also the importance of taking such measures for infants. So and that is basically the campaigns can take form of TV advertisements, but if it is too costly, then probably something on the lines of community level engagement programs at the panchayat level, where the leaders or certain representatives from the community itself can come and speak about these issues and encourage the awareness. The other thing that we were thinking of is partnerships with either NGOs or businesses which actually create sustainable modes of purifying water. So simple aquaguards that NGOs are involved with producing, and scientists with really, really small firms, which require the sort of capital that we can provide, and also that will reduce a lot of our work so that we can focus on our company itself. So we're thinking of creating partnerships like that and sending them to these affected areas where they can solve the problems themselves. And we're also looking at investing certain amount of this money in we could definitely explore investing this money in certain entries under section number 63 of the Income Tax Act, which actually exempts tax. So for example, certain donations to certain government programs. So we're looking at investing in all of those programs as well. So these are a few of the proposals that we have in mind.
Partnership with an NGO or small businesses to increase awareness of purifying drinking water before adding to the baby home. And they're also proposing that they choose the NGO with charity status so that they will be exempt from income tax, or they'll get an income tax deduction. Okay, so that's the proposal. Any questions? Is that an appropriate CSR? Does that fulfill the intention of the legislature? is it appropriate morally? Because what they seem to be doing is basically using the CSR fund to do something they should be doing anyway, which is to avoid their liability. Wouldn't you argue that? Because clearly the warnings that they have on their infant formula packet isn't being followed for whatever reason, and it's resulting in damage. So instead of increasing the warning or providing it with some infographics that explain how it should be used, or supplying a kit that will actually purify the water with every packet of formula, which is most probably how you'll fulfill your duty, really, what they're doing is they're outsourcing this duty to another NGO to undertake this activity, and they're using money that is allocated for CSR to do that. So most of the money is really going to avoiding liability in the future. Is that appropriate? I'm just wondering. I know it's within the ambit of the law.
Providing a purification kit or like something like a zero pH device which would purify the water in the rural areas would do a great deal of help to the villagers, because they have the resource coming with the kit, coming with the baby formula, so it's very easy to use it.
Instead of putting the onus on a third party to ensure accessibility, the company itself would make sure that these kits and these purifying systems are accessible to the villagers themselves directly.
There should be more direct involvement of the company.
So they could say sell these kits at like a nominal rate to rural areas and make sure that they are accessible to them.
Or maybe along with the product.
Okay. All right, so the points are being made that perhaps using the money to sell it, what you say is clearly within the law. But the point that's being made is perhaps what would be sound and more ethical is to build, I suppose, whatever infrastructure is required in villages to purify water. Secondly, to sell kits, as you were saying, at a nominal value or supplied for free with the sale of the product, rather than just outsourcing it to somebody else. So we're just trying to see how you could, as a good corporate citizen, get away with the minimum, and perhaps there's another step as well that you could attempt to do. So thank you. Let's go to the first question. Oh, sorry, I should come back. Any reaction from you? Okay. Okay, let's come back to you guys with the first question, which is the leak of noxious chemicals potentially, and how are you going to invest that money, the CSR money? Who's the spokesperson?
I don't need it.
You don't need it.
So what we thought would be a good idea was to set up a treatment effluent plant so that we treat these potential noxious chemicals on our end itself instead of it affecting the society at large. So that would be one step. And another one would be to partner with this NGO itself and conduct like awareness programs for safe use of pesticides, and set up a rural development fund of sorts to ensure that education and stuff are accessible, because it's mentioned in the schedule itself that eradication of poverty and hunger and education programs for children must be a part of your CSR initiative. So we thought we could do that. And
so, I mean, the way we looked at the problem, if there's leakage of noxious chemicals, then there's a large likelihood, there's a likelihood that it's going to be covered under one of the environmental acts. So there's Environmental Protection Act and there's Water Act. So there are large chances that it'll be already covered under those acts. Now, based on the problem, I think what we've deduced is that we're getting away with leaking chemicals. And so we sort of evolved two separate standards. One is the bare minimum that we would do as a corporation that was solely focused on profits, and only to comply with the provision in sort of not in terms of its spirit, but in terms of its letter of the law. So for that purpose, instead of fixing, these are internal discussions, must not go out to the public as as members of the
Committee.
Of the committee or of the company. We would say that instead of fixing the leakage before spending the CSR amount and having a dual obligation to spend money both for CSR as well as to fix the leakage, we could try to spend money, the CSR amount, on fixing the leakage itself. So that way we'd only have to spend that amount of money once. So in terms of what we do, we could maybe partner with the NGO. So under the rules, CSR rules, you're allowed to spend money and put money in a registered society. We're assuming it's a registered society or a trust that's been operational for 3 years or more. And so we could partner with them on trying to fix ways to reduce the ill effects of the noxious chemicals. We could also set up a treatment plant, because under Schedule 7, I mean, making available safe drinking water, ensuring environmental sustainability, maintaining quality of soil, air and water, all come under these broad categories. So we would be well within our rights to say we set up a treatment plant for water and say we've appropriately spent the CSR amount. Now there's a second standard, we could be good corporate citizens, and for that we would probably try to fix the leakage prior to having spent the CSR amount as part of our duties towards the society and the statute, which we've been getting away with. And in that case, we would probably, again, we could partner with the NGO and try to spread awareness on how to use pesticides safely. What else do we have? Do we have something else?
Rural Development Fund. So we were also thinking that we'd set up a sort of a rural development fund and say pick a particular village and involve the villagers in the decision making process and do things that the villagers actually want and fix their problems, as opposed to just saying that I will fix this problem for you. That's like two birds with one shot.
So it didn't just hit you that maybe you just give it to the Prime Minister's fund?
We could do that also. That would be
but we're trying to be good corporate citizens in the second case.
Okay. So any questions from you to this group? All right, thank you. So I suppose that's exactly the kind of thing we wanted you to bring out, and we also wanted to bring out who is monitoring this. So you have figured out this program, you have gone for the bottom line, which is not good corporate citizenship, but just whatever is the least you can do, and you've gone ahead and done it. You've set up a system for monitoring it. What happens now? Who decides whether that's okay? Let's say you don't spend it. You don't end up doing it because there's some further problem you have to actually deal with, which is litigation has started against your firm.
They are supposed to be doing without the CSR. I mean that the CSR, whatever the amount you are investing in the business, you are supposed to invest without having the CSR obligation already. Can it be so?
Well, that's a question. So the question is, what is the obligation in your number 2 problem? Has that issue already arisen in your case? Do you have a legal responsibility already in your case? Are you doing something that you already are expected to do? Is the question to you. So what's the answer? On what basis?
Because on the presumption of the further issue that it might be possibility that the leakage might be possible, and if we go for the second question, there might be possibility that if the same thing is happening in Pakistan, it might be possibility that it will be happening in India also. So on that basis, you have to, for the safety precaution, you have to go for the campaign and collaboration with the NGO and outsourcing your work and all this whatever you want to do. So what is the need of the CSR obligation here? Need of the CSR obligatory to make the CSR obligatory now?
Okay, the answer to your question is basically what you consider your legal obligation to be. That really depends on the company. Definitely, as far as I can see in that problem, there is no breach to date. Secondly, as long as you follow the standards of labeling, there is no breach. Thirdly, it is possible that there is a risk factor that it could be argued there's a higher duty of care owed because of what happened in Pakistan. But whether or not that's going to lead to some kind of action, and whether or not it's your responsibility to start up all sorts of campaigns is a question for you to decide. If the company decides no, then clearly it's not part of their duty. But if you decide yes, then clearly it is part of your duty. But what is supposed to illustrate is that it is a slippery line. It's not a clear, bright line. It's quite a light line. And you can easily cross over to just doing what might be necessary to reduce your risk. All right. Okay, so let's just, so that's the point that's made is exactly the reason we looked at these questions, to see if you can actually just take steps and spend the money to do something that perhaps you might do if you're a good corporate citizen anyway. And even in doing that, you can reduce the amount you spend. So yes, you've looked at Schedule 7, but also it's been pointed out that when you implement CSR, you can do it on your own, or you can outsource the CSR, or you can collaborate with somebody else to actually implement the CSR. So you have already raised that by saying that you might want to partner with the NGO, or you have said you're going to set up some sort of village trust, which is outsourcing it, or you've said the company itself could have a foundation, such as the Gates Foundation, that's already trying to do it within its own entity. It can set up a fund or a foundation that can distribute the money. And it's also possible to collaborate with somebody else to do this. So if there's a company that's a marketing company for the baby formula, it's quite possible to collaborate with them to try to expend the CSR amount on a joint campaign. So the point that is coming out is, although on first instance it looked like it's significant, you do wonder if it is. And as we go back to this amount, firstly, you just specify if you haven't spent it, and also the CSR responsibility, which I don't know where it is actually to devise mechanisms for ensuring that there is compliance. So the company itself is monitoring it. The only external monitoring occurs by putting it on the website. And you're supposed to actually list how you're doing it on the website. So there's hopefully someone else who might also be looking at it, and in your annual reports. So what do you think about the effectiveness of the provision, which on first glance looks like a major attempt to regulate companies and make them into some kind of moral agents? So I'll leave that with you to mull over, but I think it is not exactly clear. The next thing I wanted to go on to is sorry, I didn't deal with that, but who monitors? As we said, it's the company itself that's supposed to monitor, which is a weakness, except for the website, and the annual report, which is only really read by shareholders, mainly. But I suppose if it's on the website, NGOs might follow it up. Are the penalties high enough? As we said, it's only 5 to 25 lakhs. So sometimes maybe they're actually less than the 2%, and it's supposed to be cumulative, so you might actually postpone it to the following year to make the expenditure. And secondly, this is a problem with all comply, explain models, that there has to be a commitment from the company itself to try to engage in this activity. You've got to appreciate the problem faced by the governments and by the regulators. How can they have a model that mandates it? It'll actually require some kind of policing of the mechanism. It'll need a separate auditor to be placed to go and check out if the mechanism is fair. And it'll involve all kinds of intrusions into the company's conduct, which will be far too expensive and really time and cost-wise much too expensive to be able to impose on a regulator. So it's just far too difficult when you're talking about global companies. The next thing I wanted to look at is institutional investors. And I just briefly wanted to say, as we have already examined, companies are governed by majority shareholders who go to meetings, minority shareholders because they have all those minority protections, including class actions. You have the government because the central government has the power to also bring class actions. You've got the Ministry of Corporate Affairs, which has issued voluntary guidelines on social and environmental factors. So voluntary guideline is that listed companies have got to state if there is any social or environmental impact that shareholders should be aware of, which might affect the share price. So it's not just economic, it's social, environmental, and economic factors that might affect the share price has to be disclosed. We've already looked at international regulation yesterday, and that is things like the codes of conduct, the Equator Principles, the Responsible Investment Code. But there is something else that's becoming important today, and that's institutional shareholders. This is some figures that is fairly dated, but it is telling us that mutual funds in India constitute a significant portion of investment, and it's increasing. As you can see, it is somewhere around 130 million US dollars in 2009 is in mutual funds. The pension funds amount haven't increased that much, but the mutual funds have increased that much. So the investments in mutual funds has increased significantly. And these guys, these mutual funds, are investing this money in something else. They're investing in shares. They're investing in some kind of security. So it could be a hybrid, or it could be just shares. So the question is, how can we try to get these mutual funds to be responsible to their shareholders? So what we're talking about here is one layer removed. The people who want to put some money away for a later day, put the money in the mutual fund. The mutual fund then takes that money and invests it in companies. It can invest it in many companies, or it actually invests it in packages. So often, the person who is putting the money in the mutual fund can go for A, B, C, D packages, which is balanced, growth, risk, all these kind of packages of investment. So the question is, what about these people who are investing in mutual funds? And what about the role of the mutual funds themselves and they're investing in companies? Can we try to get these funds to do something? They're growing in importance, as I've said. The OECD report in 2011 stated that mutual funds and pensions are often very active managers. Insurance companies, on the other hand, apparently are passive, but mutual funds are very active in that they try to keep an eye on the company they've invested the money in, and they try to make as much money as possible because, of course, they also make a profit because often they are only promising a certain amount to their investors. So they've got to make sure they make that amount to be able to give the return back. In 2009, it was estimated that institutional investors were in excess of $53 trillion US dollars in equities. So it's a really big portion, and that is one of the main funders of corporations. So the question arose, with the OECD that we've really got to think about some kind of principles that will ensure that shareholders, these institutional investors, are able to firstly take care of the people who put money in them, and also maybe they can regulate companies themselves, companies in which they're investing. So the institutional investors generally act in a fiduciary capacity, and we all know that. So let's just look at how it works in India. Firstly, one of the main principles is if you're an institutional investor and you want that institutional investor to be active, you've got to know what they're doing. So you've got to be able to know what decisions they make. So the first thing is disclosure. Get that institutional investor to disclose the decisions they're making. If you want to go further, you can actually ask for voting. You can ask, how did you decide? Did you vote for that resolution? Tell us how you voted in that resolution. So you could ask the institutional investor to actually disclose every resolution and how they voted. This was actually snuck in one of the documents in 2010 of SEBI. That, yes?
But disclosing every step, there are certain investors who are oblivious of the entire market. Disclosing them won't make any sense, and at times, even the right step to them would seem wrong because there are chances that the money might not come back, might crash. So, in a way, it is just like we said earlier also, if we don't have limited clarity, then no one will take any risk. Similarly, if we don't have limited clarity, mutual funds will not take that kind of risk.
Mutual funds have limited liability.
Yeah, but if they have to disclose every step to everybody, then it doesn't make sense.
But the disclosure of the investment should be done about it. It cannot be possible about if you are going to be disclosed investment, invest the money and what way you are investing the money, it should be done now.
So what the mutual funds will do, such as AMP is an investor, is a big mutual fund, it's got a big arm that invests, it'd just be saying our balanced portfolio is invested 60% in shares, 50% in stock outside the country, and 30% in whatever. So it just gives a breakdown. And then it'll say something like, in the last year, we have been active on the following fronts. In the last AGM of these companies, we have only been active on the front of remuneration, of actually appointment of auditor, and we have been active in maybe looking at their balance sheets, checking the directors' balance sheets. And they can just say the voting was, or maybe it can be, let's just take the first two, remuneration and auditor's reports. So it can say we approved the auditor's report and we voted against the remuneration increase, where they wanted 25% increase. That's all you give.
You won't be outside that.
No, what? Sorry. So the way it is this is the institutional investor. Okay? The institutional investor is investing in companies. This institutional investor just has to say, this is the resolution and this is how I voted. Resolution 1, I voted yes. Resolution 2, I voted no, etc. Resolution 3, I didn't vote. And if they didn't vote at all, they don't have to disclose it. You assume they didn't vote. The reason for this is all these guys who are investing in this institution can then look at this and ask the question, is that institution investor taking care of their assets? Say one of these companies is Satyam. These guys can ask the question, did this institutional investor pay enough attention to these resolutions? Did they keep an eye on our money? So in 2010, the SEBI policy is requiring them to have some sort of voting policy. They can say the voting policy can be, we will vote on remuneration. And if they're voting, then they have to say how they voted. So usually, all we've looked at in corporate governance is regulating the companies themselves, right? And we have looked at the different shareholders in that company and giving them rights. What is happening now is they're actually regulating how a shareholder can work with that company and the interaction they have with the company. So what is in effect happening is they are trying to, I suppose, put some responsibility on other parties. It's an acknowledgement that it's a wicked problem. It's too complex a problem that can't be regulated by just domestic legislation. So it's asking others in the market to take some of the burden. So apparently this policy of 2010 was just put in, and this prompted a number of firms who are advisory firms to mutual firms to pop up, to develop in India. When you're looking at institutional investors, you've got to ask the question, what kind of duties do they have? So there's these duties imposed by SEBI on institutional investors, as we've said. But under the common law, these institutional investors do owe a duty to all these guys that have invested in them. They owe a duty to these people, to the people who have contributed to the mutual funds, to actually engage in due care and skill. So they won't take their money and run away. So there is a duty, fiduciary duty. There's also a duty to avoid negligence. They have also developed, or can develop in other countries, an institutional code. So a code of conduct for institutional investors on how they're going to act. In India, that code of conduct doesn't seem to have existed at present. In India, the fiduciary duty clearly exists just because of the contractual relationship and the idea of vulnerability of one group, which is taking care of the funds of these depositors. And the conflict of interest duty has not been codified, but you could say it exists within the fiduciary duty itself. So you've got the negligence duty under tort, you've got the fiduciary duty, and you might have a contract duty. And the duty, further duties has been legislated for. So this is a really interesting step that's happening worldwide. What has resulted is a new kind of institutional investor is starting to grow, and they're called proxy firms. So what these proxy firms, sorry, not investor, a new kind of institution is starting to grow, and they're called proxy firms. These institutional investors are basically financiers. They don't really want to go around figuring out how to vote. And they're frightened because they're managing many, many, many company stock. They're already engaged in getting a good return for their members or their investors. Their depositors. They really don't, they're worried. And when you start looking at the duties that's imposed on them, how do they make these decisions? Do they just employ a load of people to try to advise them on how to vote? So what has happened is that a new firm called a proxy advisory firm, PAFs, have developed. Their sole role is to provide advice to the institutional shareholder, to try to advise them on how to vote. The main things that they've been advising them on, and so what is a proxy firm? It's a really exciting development. It started up in 2010 and they're growing considerably in India. Apparently, how many? I'll just tell you in a little, well, there's Institutional Investor Advisory Services, IIAS. Apparently that's a really interesting organization. There's another proxy firm called InGovern, which apparently has been doing a lot of advisory assistance. So these proxy firms are full of lawyers and accountants. And these guys are basically, and financial analysts, and they're looking at different companies, looking at their portfolio, looking at the decisions, and they're advising the institutional investors how to vote. So an example of one proxy firm's advice, this Institutional Investors Advisory Services, was in the Reliance annual general meeting in 2012. Apparently, our auditors had been employed for 35 years by Reliance, and the same auditors had been employed for 35 years. We know that there has been amendments made to the Companies Act now that says auditors must only be employed for 5 years, a single auditor, and if it's a firm, for 10 years. You can't have them for 35 years because they recognize that there's complacency, there's a relational aspect, which means they can be influenced in an adverse way, and they mightn't do their job properly. So this institutional investor was wondering how to vote against it. So Reliance is appointing this auditor's firm, and the institutional investor has been waving a red flag, telling everyone 35 years is too long, it's not going to be secure, you really have got to safeguard your interests. And at the general meeting, all their warnings work, and the auditor's appointment doesn't go through. So what is happening is they themselves seem to be working towards trying to improve corporate governance. This is a little table I pinched off the wonderful website, and they're all votes in 2012. This is the action by proxy advisors, and the first one is in a company, Reliance, and it's the appointment of the auditors we just talked about. The second is L&T Finance, and here it is about raising money. It was a prospectus fund issue, and they'd raised money, and they wanted to vary the way in which that money was going to be utilized. Usually, most probably, it would just go under the radar. But the proxy advisors told the institutional investors, look at it, they looked at it, and they say it's fine, go ahead. So they're voting for it. In Vedanta, it was a merger with another company. They advised to vote against it. It was argued that the operational hurdles of Vedanta meant an additional debt of 50 crore. And this 50 crore debt was going to be transferred to the new entity. And the auditors, the proxy advisors felt this wasn't really bringing the benefit that was expected. It wasn't really in the interests of the shareholders. So they voted against it. In next case of Vedanta, another proxy firm, InGovern, was talking about a merger which related to the same thing as the former, and they voted for the merger because it was a cleaner structure and it was supposed to be a well-diversified portfolio of minerals. So what's interesting here is you might be giving the advice, the proxy firm might be giving different advice. Different proxy firms might be giving different advice, as is the case here. I don't have enough facts to know if it's the same matter they're advising on, but it really depends on how they evaluate risk. The final one is a merger of 3 unlisted companies, and as you can see, they voted against because they felt that the promoters were holding a big percentage of the shares, and they felt this would be risky to allow them to hold a huge percentage of the shares, which meant lack of accountability. So this is just an example of the way in which proxy firms, these guys, are advising the institutional investors to vote. and they're telling you how they are advising them to vote. Now, there's a little cute story that is talked about by this Sri Ram Subramaniam, who started out in GIAN research services. And he says that he started out and he was going to call it in GIAN governance services, and apparently SEBI wasn't very pleased with the name. They thought there were too many govern and governance in it. So he changed the name to in GIAN research services in Bangalore, and that was the first independent proxy firm that started up. And there appears to be quite a lot of use of them. The World Bank indicators, as I said before, tend to vote on whether or not a country has got sufficient mechanisms to ensure that it's a friendly place for investment of capital. It's interesting to note that in 2010, India was ranked 41st in the world on protecting investors. Remember, it's relative. And in 2015, India is now 7th in this scale for protecting investors. And the view is that the legislation, directors' liability, as well as these proxy firms have assisted in this development. I suppose one can ask the question, how does a proxy firm actually react? What does it talk up? What does it talk to? I had a look at the proxy firm guidelines that's prescribed by Glass Lewis, which is a big proxy firm that's a global entity that's also based in India. And the first thing they talked about is, well, they talked about many things. They talked about calling a meeting of minority shareholders. As you already know, you've got to have the 100 votes or 1/10, remember, to call that meeting. However, Glass Lewis doesn't like that. And they say if they were advising, they would advise a minimum threshold of at least 25% of the company's paid up capital is what it should be. Shareholders with 25% are the ones that should call the minimum meeting. So what's interesting is, even though the law says 10%, Glass Lewis is saying, forget it, that's still litigious, that's still most probably frivolous, we want 25%. So the reason I put that forth is that, you know, if 10% call it, maybe the institutional investors are not going to bother voting and nothing will happen. But if 25% call a meeting of this company, maybe the institutional investors will then think, this might be important. I'm going to go and vote. Because the proxy firm is going to be advising them, 25%, red flag, be on your toes. So it's interesting that the way in which institutional investors will interact with the company is going to be changed depending on the proxy firm. With mortgaging assets by a company, often, as you know, mortgaging these assets is pretty common, and shareholders never get to know about it. Directors in a company might decide that they should mortgage the company's assets to borrow money, to maybe diversify, expand, and so forth. The proxy firm advises that if there is going to be such borrowing, you should get a general meeting approval. So what they might do later on is, in the annual report, ask a lot of questions about how the directors made this decision. They might say, why did this happen? And they might propose an amendment to the articles and say, we want the articles amended so that if there is going to be a mortgaging of the asset, we want you to come to the shareholders. So the reason I bring this forth is to try to illustrate that proxy firms are changing the way in which governance can occur, and they've changed it hugely in Australia. The view on option repricing. So the definition of this is basically that Options are provided quite often by corporations, often to upper management, and they will backdate the price. Often this can be done in a way that the CEO is advantaged and gets more money than what was originally thought. Apparently, more than 2,000 companies between 1996 and 2000, in a study that was carried out by Professor Lai, over 2,000 companies in the United States had used this as a way to reward senior executives in a period of 5 years, between 96 and 2002. So he says, even though it might be illegal, it mightn't be appropriate, it's done constantly. Shareholders obviously carry a substantial risk with this kind of pricing. And Glass Lewis says that we believe that employees and officers who receive stock options should be similarly situated to align their interests with stakeholders' interests. And therefore, they argue repricing is retrading and it should not be allowed. So they actually condemn this idea of option repricing. So if you're coming up at a meeting saying that you're thinking of issuing your directors with this kind of security, the proxy firms are going to be advising vote against it. The most active that they've been is in the area of remuneration. Usually they're fine, I guess, as long as it comes in within the deadline. In Australia, that's the area they've been really active. And they have advised that they will come up in the newspaper before, they'll be reported in the newspaper before the annual meeting, saying we are going to oppose any remuneration increase because the company hasn't done as profitably as we'd like them to have done. Therefore, no increase is going to happen. So that kind of action is most probably going to happen in India in the future. So far, they have just simply stated the 3% total for a CEO, they've just stuck to the letter of the law and said you can just do what the law suggests. But it's highly likely that with this kind of scrutiny, looking at bonuses, remuneration, there's likely to be more I suppose, policing of this kind of activity. So what do you think? I think this is like one of the coolest inventions ever, and I love it. However, there is a problem. Let's look at the problem. Especially in a country like India, proxy firm Invins Limited gives advice to a pension fund to invest in a company which is dealing with toxic waste storage in India. This waste is coming from other countries. The proxy firm is being pressured by the state government, this state government, which wants more investment in the state. So it has estimated the risk of being subject to any litigation or detection as very low. What I haven't said there is, let's assume that there are two companies that are deciding to actually invest in this kind of storage activity. The proxy firm says it's going to vote yes. So, the question is, has the proxy firm breached any duty? Let's, of course, assume the worst because we're lawyers and nothing can end happily. Everything must be miserable. So let's assume that there is a huge disaster and the storage, of course, isn't safe and it causes significant harm to environment and humans. So the question there is, what is the liability of the proxy firm? And let's also assume, because it's juicy, that the pressure from the state government includes a golden handshake of money. So far, these proxy firms aren't really being regulated at all. There's just I suppose they're only regulated by contract because they're giving advice to these institutional investors. These institutional investors are being regulated, but these proxy firms aren't being regulated. It's just contract law. So the question is, if they're going to be in such an important position, and if they're going to be advising on significant things, and if we assume that institutional investors, even though they are maybe only small, they have much greater influence on company direction, shouldn't these proxy firms be liable? And should they be regulated, or do we just forget about it for a while? So that's a question to you, but not to answer it directly in an abstract manner, but rather to answer it through that problem of a worst-case scenario. Proxy firm gives advice to institutional investor to invest in a company. Institutional investor invests in the company. That's a pension fund. And they invest in the company, which then then goes ahead with the storage of toxic wastes. Damage ensues. What's the solution? What can happen? I've been told that just because you say nothing doesn't mean you don't know the answer. I've been told that it's just because you're shy. So maybe I should just ask you individually. And this is when no one looks at me. No. Yes, go ahead.
So this kind of sounds similar to when in the US, when there was the financial crisis, you had those credit rating agencies that were wrongly rating the securities, and which is why the market kind of got in trouble. Is this like a similar sort of scenario?
It's quite a good point you make, because rating agencies are also like proxy firms in the periphery, but they do indirectly regulate the company. They give the company a AAA rating. It means that people think, great, this company is really secure, and they invest in it.
There are also regulations for credit rating agencies.
Yes.
As opposed to this example where you said.
Exactly. So credit rating agencies, exactly because of what you said, because of the way in which their advice did cause loss, but they weren't regulated. Now, most countries have introduced regulation of credit rating agencies, which is just disclosure. Yes, speak up. Tell us. Share it with us all.
She's just asking me whether we were talking about regulating credit rating agencies.
Yes, so I don't know if they're regulated here. I presume so. They're definitely regulated across the world now. And the theme of the regulation, the underlying philosophy is disclosure. Tell us how you got there, and have some kind of Chinese walls between your services. So often, of course, credit rating agencies give ratings, but they also give business advisory services to improve your business, typically. So to have a wall which distinguishes, which keeps those two services separate. So, what do you think? Think about anything, about a beautiful day, about this problem, about your next assignment. Anything at all, share it with us. About what you share, we'll know what you're thinking about. Okay, so the point is being made that there is a fiduciary duty here. That is advisory services that's being given. And perhaps they've breached their fiduciary duty. They've most probably breached their contract duty, clearly, because the contract duty will include the duty to be honest, not to make a secret profit on the side. There'll also be a tortious duty, presumably, to exercise due care and diligence, not just say go ahead with it. So did everybody get that? There'll be some regulation after a crisis, but not yet. I'm sorry, I can't hear you. Okay, so the point has been taken one step further, and we've noted that they might be the heads of liability, but the point's been made that there is pre-existing knowledge that this is a pension fund and there is significant amount to lose, and the investment is in toxic materials where there's significant loss that should be factored in. So that might actually mean that these duties are easier to breach. All right, so you're quite right. And that's exactly what credit rating agencies' regulation is. It doesn't try to provide a remedy or a fine. It just provides a process for disclosure and a process for carrying out activities within it. You know, those Chinese walls I mentioned before. But you still go back to these remedies, or sorry, these heads to get a remedy. So similarly with the proxy firms as well, to date, the regulation is only going to be one of, sorry, there's no regulation at present, but if there is, it's going to be a GIAN disclosure, but as you say, it'll come in due course.
There's some regulation which is there. So in September 15, SEBI passed the research analyst regulation. And proxy advisory firms have been defined, and they also have to be registered with SEBI for those purposes. But still, not all are getting, because they may or may not follow the definition of research analyst, as you say.
And what is the requirements? What is the actual way they're regulated?
So they have to get registered with SEBI. They have to make disclosures of what employment they are hiring. They have to make disclosures as to what is the knowledge base of those employees and how experienced are they. Then only they can operate. But
so what is the result? Sorry, okay, the penalty provision?
The penalty provision is not there in the regulation. It's still under the main SEBI Act. So now how in India capital market.
So can I ask you, what is the aim of that then?
So the aim actually was at 2-3 levels. One was all the market advisors which are otherwise operating, who are not SEBI registered investment advisors. That's a separate category. These plus proxy advisors, because they're in this business, to cover them and other such advisors, SEBI had passed these regulations. The research analyst regulation, I think, passed on 1st September 2015.
Thank you. I wasn't aware of that. Thank you. So I suppose that just goes to show that they're trying to get someone registered The central government seems very keen on getting everyone registered and also retaining... Or remedies, or duties. So the main thing is, what duty do they owe? So, okay. So let's just leave that, and let's just say that this is an area that we can watch with interest. Okay. So to conclude, I don't even think I put anything up next. Oh, no, I haven't. To conclude, I was just trying to bring to your attention that it's sort of a growing field, that we don't really know. We're still relying on old contract rules, and all that the government can ever do in these instances is try to increase the flow of information to people who might then have a right to it and make a decision via it. So it's been an interesting development. Now, I have a problem for you. So what I'm going to do now is I'm going to distribute the problem and talk to it a little bit. And I've been asked by Subramaniam if he can come and do an evaluation at 4:15. Thank you. And for the gentleman behind you. Oh, they've got... Okay, if there's anybody missing, please take one for them. There'll be some here. If you want to take one for your friends who aren't here, please do. So let me just talk you through the question. The reason I put this question together is I was talking to many of you yesterday at the dinner, and I was mortified yesterday because there was such a lull, and it was like this still afternoon air, and everybody was absolutely bored out of their brain. So I just thought maybe I should do something. It's my responsibility. So I was talking to people, and they said, well, have a few more questions, have a bit more interaction to see how a section kind of pans out, how it's implemented. So I wrote this question, and it's a corporate group, and what it's trying to do is bring all the issues we've learned into discussion, and I hope to do that tomorrow. So Metro is a group of companies, and it includes 3 companies: Metro India, Metronomics Developments, and Metro Robotics America. And they're all involved in different aspects of property. Metro India has a diverse base, 70% shares held in individual investors in India and overseas, 17 held by institutional investors, 3 Indian banks, and 11 held by a pension fund, Franklin India Pension Fund of India. Yes, sorry about that. That's a bit of a typo. Franklin India Pension Fund of India. Metronomics Developments is a wholly owned subsidiary of Metro India. Metro Robotics America has the following shareholder groupings: 51% by Metro India, the parent company, 20% by investiture, and the balance by 2,000 disparate shareholders in India and US. The same persons are director of all 3 companies: GIAN, Bala, and Pali. The events in question, and then there are some problems that arise. The first is the directors approve certain accounts which do not fit with the accounting standard. They've been advised by the auditor and by the accountants. The second is the Metronomics decides to refinance its money from Eastpac, but they can't because Eastpac is not wanting to, they decide to refinance the money with West End Bank, and they go there because Eastpac doesn't want to lend them the money anymore because they've defaulted, and they go to West End because Gian's uncle's second cousin, and also a childhood friend, is a director of West End Bank, and he pulls strings. The bank agrees to make the loan of 100 million and waives the necessary solvency declaration. There's a special fee of 5 crore that's paid to the friend uncle's second cousin. The directors are proceeding because it's the only way they can get the company moving. The third scenario is the directors are considering a merger between Metronomics and Metro Robotics, and they're being advised by Freedom International lawyers. The merger went ahead. However, the directors failed to disclose guarantees of the short-term liabilities of Metro India. And the AGM, so these guarantees were provided by Metronomics to Metro India. And the directors are particularly concerned of what the institutional investor, shareholder, is going to do. They're worried because that is a very active investiture. The institutional investor has been ringing the directors on a continuous basis, asking them about the next steps, so they know they're trouble. Metro Robotics has enormous success with an invention of a robot with enhanced cognitive capacity that can make many managerial decisions for companies operating in the SME sector. This is welcome in the market, and the price rockets, share price rockets by 45%. The directors of one of the parent companies is very pleased about this and decided to give themselves a big hike in remuneration of 2 mil each. However, the profits have fallen partly because Pali has sold her business to Metro, and Pali is one of the directors. And then you've been asked to divide yourselves into 6 groups representing different interests, and you're supposed to answer the question on the 3rd page. There are 5 of them. So there are 6 different interest groups. And some of the interest groups are rather large, like the lawyers, and they should involve more than 1 or 2 people. But others, such as just the pension fund or the accountant, could just involve 1 person. Do I have takers? Who wants to be shareholders of Metro Limited, who are constantly protesting, saying, what about me? It isn't fair. So what about, you want to be shareholders? Yes. So you have to ask a lot of questions of the directors and make trouble for them. So shareholders will include persons representing the 3 groups, individual shareholders, 3 banks. You don't have to represent Franklin Pension Fund, but the 3 bank and the institutional shareholders. So do you too want to do that? Are you coming tomorrow? So you too want to do that? Anyone else want to join them? They could use 1 more person. Okay, we'll just see. The next thing is investiture, the venture capitalist, who is the institutional shareholder. Who wants to be that? Yes? The third is freedom lawyers. We most probably need 4 people minimum for lawyers. They're the freedom lawyers and they're advising all the parties. I'll just finish, I'll just be a minute. Freedom lawyers, who wants to be freedom lawyers? Maybe you should. Do you want to pick some other friends to be freedom lawyers? Anybody? You can't do it all on your own. I know you can do a lot of things on your own, but not this. Okay, maybe you don't. Maybe you can be the accountant. You can be the accountant. You can be the prized accountant and auditors. Who wants to be lawyers? What about this gang here? Well, you missed. Oh, you want to be the director. Okay. Okay, who wants to be the director? We need 3 directors. So the 3 of you who put your hands up first. All right, so you have to ask the lawyers questions constantly, but you also have to be aware of the facts. You know what they're going to say, so you've got to ask them questions on what they're going to say. So we still have the lawyers left. What about you guys? Pension fund is, no. We need some lawyers. That's what you're doing. That's a degree, you know, law. Everyone's looking away? Come on, guys. Who isn't here? Maybe we can dob them in. I think you should be lawyers. Are you coming tomorrow? You should be lawyer. You should be lawyer. 4 lawyers. The directors were already chosen. The only person left is the pension fund. You want to be pension funds? Good. Thank you. The rest of you have to be judges. Ask questions on each question. So yes, so thank you for just hanging back. That's your job. So now you're going to have evaluations, but after that, I'm more than happy to help you. Maybe if you want to come up 2 hours before the class, I can have a chat tomorrow. I'm usually in that room around the corner. So thank you very much. And please do the evaluation.